It's been quite a year, so thank you all for coming. And for the folks online, thank you for joining us as well. Both of our speakers are from Vinson and Elkins. Felita Tennant is a graduate of Harvard Law School, a Texas native, and a fourth-generation Houstonian, and is a senior associate at V&E's Houston office, where she focuses on employment litigation before state and federal courts and administrative agencies. Her practice includes counseling and investigations. Felita is particularly experienced in litigating employee non-competition and non-solicitation agreements, seeking injunctive relief to protect employees' trade secrets and defending employers from whistleblower claims. Vinzi Vaya is our other speaker. She counsels companies regarding antitrust compliance and competition risk across a wide cross-section of industries, including defense, public procurement, transportation, consumer goods, financial services, and technology. She represents companies and individuals in criminal antitrust investigations and class action and civil litigation-related competition. Lindsay also co-chairs the American Bar Association's Antitrust, Cartel, and Criminal Practice Committee. Thank you all, and I hope you join the panel.
Hello, welcome, good morning. Thank you so much for joining us. If you're dialed in to hear a discussion about what the fuss is about no-poach agreements and non-competes, you are in the right place. I'm Lindsay Valla. I'm a member of the Antitrust Practice Group at Vinson and Elkins, and I'm based in Washington, D.C. I spend a lot of time helping companies and individuals navigate enforcement actions and internal investigations related to competition. And I also represent clients in all manner of antitrust-related litigation, both on the defense and the plaintiff side. We have seen an uptick in companies reaching out to strategize with us about best practices for antitrust compliance, particularly given the recent administration change and some recent policy developments within the DOJ Antitrust Division. In addition to my V&E work, I chair the American Bar Association's Antitrust, Cartel, and Criminal Practice Committee, and I have spent a lot of time recently thinking and writing about some of the developments and trends that we are going to discuss today. We have a lot to cover, so I'm pleased to turn the mic over to my colleague Felita to tell you a little bit about herself and kick off our agenda. Before I do that, quick housekeeping matter. I want to remind you that if you have questions, please put them in the chat function and we will try to address them as we go along. Felita, over to you.
My name is Felita Tennant, and I am in the Vinson and Elkins Houston office in the Labor, Employment, and OSHA group. And I've spent most, if not all, of my career litigating issues related to non-competes, protection of confidential information and trade secrets, also advising companies through the offboarding and onboarding of employees, particularly as relates to matters of securing the company's goodwill and proprietary data. Restrictive covenants, I found, are something that often become an urgent or even an emergency level enforcement priority. And my experience has been that the advice that we give ahead of time can very often make handling of those emergencies much easier. So I'm hopeful that today's presentation will guide the members of the association into seeking advice on not only restrictive covenants, but also antitrust concerns, so that when and if the time for litigation arises, you'll be ready. I'd like to first go over the agenda for today's slide. We will first discuss the enforcement priorities that Lindsay and I see coming from the Biden administration as concerns antitrust. Next, we will talk about the mechanisms for criminal liability for antitrust violations. Following that, Lindsay will take a look at some of the key HR practices Department of Justice is particularly focused on right now. Then she'll walk you through a series of case studies looking for practical takeaways that can inform your company's practices. Then she'll turn the mic over to me and I will discuss the current environment for restrictive covenants and ongoing changes in hostility in that landscape. Finally, we'll wrap up with practical considerations for restrictive covenants and employment agreements, of course, followed by answers to your questions. So, as promised, the enforcement priorities under the Biden administration. Here we have two quotes from the Biden administration's plan, highlighting the fact that we fully expect the Biden administration to be a pro-work, pro-American worker administration. And what that means is that they will be committed to enforcing antitrust laws and as Biden has promised, committing to eliminating non-competition agreements and no poach agreements. That means we need to have a talk about what we're going to do to protect those enforcement mechanisms within your company. We'll talk about this in much more depth shortly, but I wanted to set the scene that no poach actions, which Lindsay will discuss later on in our presentation, really have the root in their guidance that was issued jointly by the FTC and DOJ in 2016, right at the end of President Obama's term. We expect that Joe Biden, then Vice President Joe Biden, will continue the focus classic to the Obama administration dialogue, which was that agreements to limit or fix the terms of employment for potential hires may be a violation of antitrust laws. Now over to Lindsay for a more in-depth look.
Thank you, Phillida. So I'm gonna show you this busy slide. We're gonna talk about these indictments definitely in more detail as we get going here, but I really wanted to give you a summary so that you kind of have the facts of these indictments in your mind as we continue the discussion. DOJ is really busy bringing criminal antitrust cases in the no poach space. There's 2 in Texas and 1 in Nevada right now. There's been 3 in just 3 months. As you can see from the description on the slide, there's a range of no poach and wage fixing conduct alleged in each of these indictments. And I think I point them out here because they are a really good roadmap for the conduct that DOJ is really focused on. I also wanted to mention that there is a new statute. Congress is getting in on the action, and at the end of 2020, the criminal antitrust whistleblower protection statute was passed. It is a remedial statute. It does not seek to provide bounty recoveries for antitrust whistleblowers, but it is intended that if a whistleblower reports either internally within the company or directly to the government, and if they experience retaliation, the statute aims to make those employees whole. So I mentioned it here. We're not going to talk a lot about it, but I wanted to make you aware of it because I think it's another tool in the government's tool belt to encourage whistleblowing in this space. So let's do a quick refresher on a quick refresher on criminal antitrust enforcement. I don't know how many of you have the occasion to think about antitrust enforcement in your day-to-day roles. Criminal antitrust violations are prosecuted under Section 1 of the Sherman Act. The language is a little bit convoluted, but put very succinctly, Section 1 prohibits agreements to unreasonably restrain trade. So a company acting alone cannot violate Section 1. You might have issues under Section 2, which deals with monopolization, but for Section 1, you need at least 2 parties. Agreement is broadly defined. You do not need a signed contract or even anything in writing to have an issue. The government just has to establish that there was a meeting of the minds. They often do that by using documents and written communication coupled with actions that each of the parties took that suggest that they were adhering to an agreement. I'm not going to spend a lot of time talking about the standards, but my main point here is to note that there are 2 general standards of review in antitrust cases, the per se standard and rule of reason. From DOJ's perspective, no poach conduct and wage fixing should be evaluated under the per se standard. And that's important because per se violations are presumptively illegal. DOJ has even intervened in private litigation between private parties to inform district courts of its view that no poach conduct should be analyzed under this per se standard. That is a very unusual development and signals how strongly DOJ feels about this area. In per se cases, defendants are generally not afforded the opportunity to argue that while the conduct may have had anti-competitive effects, there were also pro-competitive justifications and the intent was good. None of those arguments are possible in a per se context. Also in a per se situation, anti-competitive intent is assumed and anti-competitive effect is also assumed. Classic per se violations are price fixing, bid rigging, market allocation. An example of market allocation is you sell to customers east of the Mississippi, I'll sell to customers west of the Mississippi. To understand DOJ's view about why no poach and wage fixing conduct is illegal, it's important to understand that DOJ considers wage fixing to be akin to price fixing and no poach to be akin to market allocation. I included this next slide just to juxtapose per se analysis against the much more liberal rule of reason standard. Rule of reason is really a balancing test. The court will look at a wide range of factors, some anti-competitive, some pro-competitive. Defendants often make arguments about business justifications for the conduct that's being analyzed. In the no poach context, as I already said, those types of arguments are not available. I get a question a lot that I want to preemptively address here. It's very common to have non-solicitation clauses in various business documents, teaming agreements, joint ventures, various M&A transactions. Those non-solicitation provisions are evaluated under the rule of reason, and they are not the type of agreements that DOJ is focused on. DOJ distinguishes a, quote, naked no poach agreement as one that is not ancillary or otherwise related to a legitimate business arrangement. So a naked no poach agreement is treated criminally as a per se violation. To put a finer point on it, a provision in a joint venture agreement not to solicit one another's employees for a certain period of time, for say the life of the JV or maybe 6 months after, that would be analyzed under the rule of reason. And those kinds of provisions, they should be thoughtfully and narrowly tailored, but they are quite common. And that's not the conduct or the type of agreement that we're talking about today. So as a reminder, criminal antitrust penalties are no joke. For companies, the statutory fine can be up to $100 million. However, DOJ can alternatively pursue penalties of 2 times the gain or the loss resulting from the conspiracy. Depending on the context, that number, 2 times the gain or loss, can be much, much larger than $100 million. Individual defendants face fines of up to $1 million and jail time of up to 10 years. We'll have a slide in a few minutes that shows that the average sentence for criminal antitrust violations currently is 18 months. Another significant factor is that it's expensive and time-consuming and disruptive to defend against criminal antitrust investigations, even if the DOJ ultimately brings no charges, or the investigation ends in a deferred prosecution agreement without a conviction. These investigations often take at least a year to resolve and longer if there's actual misconduct. Criminal antitrust investigations often lead to subsequent civil litigation. Once an investigation becomes public, even if it's resolved without charges, plaintiff counsel race to file class actions on behalf of impacted purchasers or consumers, and in the no poach space on behalf of employees. In the civil context, antitrust damages are trebled, and there is joint and several liability. We are increasingly seeing state enforcers bring antitrust cases. We're definitely seeing that in big tech, for example, but states have also been active in prosecuting franchise agreements that contain restrictive non-competes. Lastly, it's worth noting that if your company does business with the federal government, you may be subject to suspension or debarment proceedings if convicted of an antitrust crime. Given the in-house crowd today, I want to take a few minutes just to mention compliance. Robust, effective, and thoughtful antitrust compliance is more important than ever. There are a few reasons why I say that. First, DOJ's Antitrust Division has a unique corporate leniency program. This is completely unique to the Antitrust Division. For decades, this program is how the division brought most of its biggest cases. Under the leniency program, a company that believes it may have a criminal antitrust violation can self-report that suspicion to DOJ. If the company turns out to be the first to report the conduct, the company and any cooperating culpable employees may qualify for complete immunity. This means that companies who are co-conspirators often race one another to the Department of Justice. Only the first to get to the door gets the immunity. There may be lesser mitigation credit for the second or the third in the door, but that credit is dwarfed by the value of full immunity. Another point is that in 2019, the Antitrust Division made a major policy change with respect to compliance. After years of refusing to acknowledge that mistakes can happen, even with the most robust compliance efforts, the division did an about-face. They announced that they would consider mitigation credit for companies that had in place a robust compliance program at the time of a violation. In connection with this announcement, DOJ listed a variety of factors that they would consider in evaluating the strength and effectiveness of your company's compliance program. They acknowledge that good compliance programs are not one size fits all, but they did signal that they would be focused on whether antitrust compliance is a top to bottom effort. Tone from the top is important, but so is the tone from middle management. If a senior executive is involved in or aware of misconduct and turns a blind eye, that will almost certainly disqualify a company from mitigation credit consideration. Companies also will likely have to self-report in order to have the best shot of getting credit. DOJ wants to see a specific compliance officer dedicated to antitrust compliance. So now is a great time to take a fresh look at your company's antitrust program and consider whether there are changes you could make to the structure or to your policies to further strengthen the program. I have heard from a number of compliance professionals that this DOJ change and the guidance in particular that was issued by DOJ was actually very welcome and gave compliance personnel the ammunition that they needed to go to top management and push for stronger policies and better funding. All right, now I'd like to talk a little bit about the heightened focus in particular by the Antitrust Division on the HR and recruiting space. And before we get into that, I'd like to kind of set the scene. These two slides, and particularly the one on the left, I've included it to try to explain why DOJ is so focused on no poach cases right now. As we've said from the beginning of the presentation, this is a new area of criminal enforcement for the Antitrust Division. Just that fact is noteworthy. It's very unusual to have a new crime in an area that has been around forever. So here's my theory about why DOJ is hyper-focused on this. As the chart shows, criminal antitrust enforcement penalties recovered by the Antitrust Division have fallen sharply during the Trump years. In part, this was due to differences in enforcement priorities between the Obama administration and the Trump administration. No question that was a factor. But look at the Obama years and look at 2015, 3.6 billion in fines and penalties collected. And then the last year of the Trump administration, 2020, we're up to 529 million from a low of 67 million in 2017. This drop between administrations is not exclusively due to priority differences. 2015 was a heyday, and there were multiple global investigations, many of which stem from leniency applications, and they resulted in a lot of pleas and indictments and lots of fines. And so it's natural after so many banner years in a row that the numbers fell off a little bit while the division tries to refill its investigation pipeline. And that's the rub with no poach cases. The Antitrust Division is trying some new things to refill that investigations pipeline. Honestly, I could do a whole nother presentation on all the different things that DOJ is doing. But for today's purposes, one of those things is these new no poach criminal cases. As we mentioned in the introduction, there have already been 3 criminal indictments since December in this area. And those are all in healthcare related fields. I think it's physical therapists and physical therapist assistants. There's one involving nurses, but there are additional investigations underway in other industries which are not yet public. And we happen to know because we are involved in some of those non-public investigations. The other chart on this slide is the one that I mentioned a few minutes ago. It shows the average prison sentence for individuals convicted of antitrust crimes. For the past decade, that average has been 18 months. But look at the 1990s. It was just 8 months. DOJ has a theory that a very powerful form of deterrence is prosecuting individuals. And so they have worked hard over the last 20 or 30 years to really increase and ask for longer sentences for individuals convicted of antitrust crimes. And as this chart demonstrates, they have largely succeeded. So Philida mentioned very briefly in the introduction the 2016 guidance issued by the Department of Justice and the FTC, in which they announced that no poach conduct going forward would be treated criminally. I want to talk a little bit more about that guidance. The target audience was HR professionals and employees that were working in recruiting and hiring. This is a very busy slide, and I specifically put highlights from the guidance on this slide. The guidance is available online, and if nothing else today, I hope you will all walk away from the program with a plan to educate your human resource personnel, your recruiters, and other employees involved in hiring about the risks in this space. Give them this slide. Give them the antitrust guidance. I've seen firsthand that despite the fact that this guidance from the Department of Justice is more than 4 years old, many people have no idea that this conduct is illegal, is going to be treated criminally, and can get individuals and their companies in serious trouble. The purpose of this slide is to summarize what no-poach conduct is and to highlight some recent indictments. The conduct that DOJ is focused on is agreements between employers not to solicit, recruit, or hire one another's employees. And if you had to rank them from worst to least worst, no hire is the worst in DOJ's eyes. A no hire agreement completely restricts an individual employee's mobility. Recruit and solicit are similar. Generally, in these cases, companies agree not to directly reach out to one another's employees. They may not bar one another from hiring employees who initiate the outreach themselves. It's more of a we can't contact you employee, but if you contact us, we're allowed to chat situation. Similarly, wage fixing agreements. Wage fixing is not limited to salaries, so it's not specific about setting salaries or reducing salaries for particular positions. It's much broader than that and includes agreements regarding non-monetary benefits or compensation. The 2016 guidance actually offers as an example that it would be problematic for two employers to agree that they will no longer offer or sponsor employee gym memberships, for example. I also want to emphasize that saying something like, I agree, is not necessary for DOJ to infer a conspiracy or an agreement between employers. Exchanging detailed, sensitive information regarding wages, compensation, benefits may be used by DOJ to infer a conspiracy, particularly if both of the parties then act, even unilaterally, but at the same time. I mention this because types of information exchanges may seem innocuous, right? They may occur somewhat naturally at places like HR conferences or other gatherings of HR professionals. So please tell your HR folks that this type of information, even if it's exchanged, but there's no formal agreement, can get you into trouble. All right, let's talk about some case studies and some practical considerations. I want to note that this is an evolving space. Criminal enforcement of no-poach conduct is an evolving space. The DOJ is not without its critics. There are some, or maybe even many, who think that this conduct should not be treated criminally, at least not yet. So DOJ has an indictment. It was issued in January of 2021 in Texas. It's against a company called Surgical Care Affiliates, which I believe is a subsidiary or an affiliate of United Health. It is a wage fixing and no poach indictment, and Surgical Care Affiliates has moved to dismiss the indictment on due process grounds. And perhaps even more importantly, the United States Chamber of Commerce has filed a concurring amicus brief, and that's a very significant development. The Chamber of Commerce is saying that this conduct should not be illegal. I'm watching this case very closely. I think it's possible that the defense may lose in district court, but this is certainly headed to the Fifth Circuit, and I think the motion to dismiss and the amicus brief are written with the Fifth Circuit in mind. Even if the defense ultimately prevails, I do not think that DOJ is going to drop these cases. In fact, I think this is going to encourage DOJ to redouble its efforts in the no-poach space. They may file additional cases in other courts so they can try to test the strength of the criminal enforcement action in another jurisdiction. They can always bring these cases as civil enforcement actions, which would allow them to seek treble damages if they wanted to. And quite frankly, defending against a civil enforcement action is just as onerous as defending against a criminal investigation. So regardless of the outcome in the surgical care case, this is undoubtedly an area of scrutiny that's not going away, and it's a major focus for the Department of Justice. They have been crowing about this area for the last 4 years, and I think they really need a win. So there are some precursor civil actions that I think led to DOJ deciding they were going to prosecute this type of conduct criminally. This is again a busy slide. The purpose is to highlight that civil enforcement actions came before the recent criminal focus. Starting in about 2010, for several years, DOJ investigated a series of agreements between very high-profile tech companies on the West Coast. There were lots of different participants. Most of the agreements were bilateral, so between two companies, but they were all kind of in quick succession, and there was overlapping participants in the agreements. The agreements included non-solicit agreements, no hire agreements. They agreed to confer if an employee from one company applied to another. They'd call and talk about whether or not they could interview that person. Apparently, the evidence was very clear that the agreements were struck at the highest levels of senior management, but then implemented by internal and external recruiters. So the internal and external recruiters were told who they could and could not talk to or reach out to or pursue in recruiting. Generally, those high-tech cases focused on technical and specialized employees, such as software engineers and digital animators. Think about employees that are difficult to lose or expensive to train. So the high-tech litigation, those were resolved via civil settlements between the companies and the Department of Justice, and then the class actions were filed on behalf of employees. The initial potential class was massive. I think the complaint named every employee, or was purportedly on behalf of every employee for all of those companies for something like 10 years. And a class was certified. It was before Judge Koh in California. And the class was certified, but the certified class was considerably more narrow than what had been alleged in the complaint. I think the focus was really on the technical positions, but it was still a significant swath of employees across these various companies. There was a class action settlement, and it exceeded $400 million across the cases. There's also a more recent civil enforcement action. Shortly after the 2016 guidance was issued, DOJ announced a civil enforcement action against a number of rail suppliers. DOJ went out of its way at the time to make clear that even though the guidance had already been issued and they had said they were going to treat this conduct criminally, that this particular rail supplier case was a matter of prosecutorial discretion, and they had decided to bring it as a civil enforcement action because the conduct had largely stopped by the time of the 2016 guidance. I want to emphasize that the rail supplier investigation, which again was, I think, announced in 2018 or late 2017, the conduct at issue there came to light through a merger review. One of the rail suppliers purchased another, and in the context of the antitrust authorities reviewing that merger, they found emails suggesting that there had been a no poach agreement. So that's a practical tip to take with you. You should expect that if you have an acquisition and it's reviewed by the antitrust authorities, that they will be screening your documents for other things like no poach conduct. There was also class action filed by the employees in the rail supplier matter, and I think it's still pending. DOJ intervened in the class action to file a notice informing the district court that from DOJ's perspective, the conduct should be considered a per se violation, while the defendants argued for a rule of reason treatment. You know, these cases have some recurring patterns. We see them in the civil cases I just talked about. We see similar patterns in the 3 recent indictments. We're going to talk about this again in a minute, but bad documentary evidence has a huge impact in these cases. Recent indictments quote from emails, texts, and other communications and documents. And generally, as I said before, the pattern seems to be that senior management strikes these deals or these agreements, and then HR personnel or external recruiters are asked to implement them and to enforce them. And they do enforce them in some cases against one another, or they report, we understand you reached out to employee X and I thought we had an agreement you weren't going to do that. So that is all that evidence is developed through written communications that sort of document these agreements. And then I already noted that the high-tech employee investigation led to a class action. I just wanted to emphasize again that these class actions are very painful from a dollar's perspective. They lead to huge settlements, treble damages, joint and several liability. And they're also a further distraction. After years of investigation by DOJ, you then have to turn and defend against a major class action. So I want to spend our last few minutes before I turn this over to Phillida to talk about some takeaways. So like the 2016 guidance slide, this is another slide that I really hope that you'll remember and refer back to if you take away nothing else from today. First of all, and I think this is particularly important to think about as you think about your individual company and the industry in which you operate, it's really not hard to understand how these no poach discussions come up. Sometimes it's in specialized industries, right, where there's not a lot of qualified employees to go around because it's a very technical space. Companies invest in those employees, they rely on them, and it's really painful to lose them and see them walk out the door to a competitor. We also see no poach agreements applied to senior management. You don't recruit my top finance people and I won't recruit yours. We see this type of conduct arise in tight-knit geographic markets. So there's actually a recently filed class action focused on fintech employees at 3 institutions in Wilmington, North Carolina. That complaint is public. And it alleges that if you are an employee who works in fintech and you live in Wilmington, North Carolina, you really only have 3 options for employers. And if those 3 employers have gotten together and agreed not to hire from one another, that means that if you want to have employment mobility or choices in where to work or seek a promotion somewhere else, you really can't do that without having to move to another city because of the agreements between the employers. This conduct can also happen when a new player enters a specialized market. So the new player wants to hire very experienced top talent, may go to the top company in town that already has developed this expertise and recruit its top people away. And if too many people leave that well-established top player, suddenly that top player is left with significant losses and multiple positions to fill. These agreements, I've also seen them pop up. They can be the result of goodwill between companies, right? You may not want to raid your competitor's top talent and potentially put them out of business or harm them in a particular area or department. We've heard about companies issuing cease and desist letters to one another, demanding that they stop hiring employees away. So there are a lot of factors and a lot of ways that this can come up. And a lot of those things are pretty innocuous or seem to be innocuous. And so I think this conduct that isn't, obviously illegal to a lot of people arises very easily. The other point I want to make is that bad documents do not get better with time. If DOJ opens an investigation, the first thing they're going to do is send you a subpoena for all of the documents and communications regarding hiring and recruiting. That is a very broad request. They want to see your emails and your texts and your other written communications. And people are putting this stuff in writing in part because they don't know that it's wrong. In the recent indictment in Nevada, which was just filed in March of 2021, DOJ quotes from communications between competitors in which they agree that if the nurses that they both employ come and ask for raises, both companies will refuse those requests. And one email even states, quote, "If they ask, we will tell them to kick rocks." That's not the type of email that you want the DOJ to have. So as a compliance point, consider running searches across emails, employee emails, looking for samples. So run things like Poach or language that would pull back discussions about agreeing not to hire or recruit from one another. If this conduct is happening within your company, you definitely want to know about it. Also use the recent indictments as training tools to educate your people about the risks in this space and to help them understand what they should be looking out for. If another employer contacts one of your people and suggests a no poach arrangement, you want your folks to know that that's problematic and to report it up the chain. Give careful thought to who in your organization is best positioned to help the company avoid risks in this space. Every company does recruiting differently. I've seen companies where HR really runs the show. They choose who to interview, they bring them in, they kind of run the whole recruiting process. For others, hiring is really more of a business unit decision, and HR is really more there to do the paperwork and maybe the background checks, but isn't making substantive decisions about who comes and goes. So think about how your company recruits and think about who is in the best position to identify the risks in this area and then train those folks. And if you have external recruiters, make sure that they are also aware of the risks in this area. So I could go on and on about this, but in the interest of time, and because I know Philda has lots of interesting things to say as well, I'm going to pass the baton to her.
Right. So it is a politically hostile environment at the moment towards non-compete agreements. And in some ways, this is just cyclically driven by the fact that this is a Democratic administration. As Lindsay referred to earlier in our presentation, we can look back at as early as May 2016 and see the animosity and the opinion circulating among the executive branch that non-competition agreements have a detrimental effect on the workforce overall. And so a question that everybody's asking now, of course, is how the Biden administration will treat non-competes. And in fact, the big red letter question is whether or not the Biden administration will attempt to ban non-competition agreements altogether, which is a pretty big question and a pretty new question for this area of the law, which has heretofore been governed largely by the laws of different states. What you can see here on the screen is a quote from the Biden administration's plan, in which Biden promises that he will work to eliminate non-compete agreements, except for the very few that are necessary to protect a narrowly defined category of trade secrets, and outright ban all no poaching agreements. So, it's a pretty strong statement, especially given the fact that many businesses rely upon non-compete agreements in order to defend and protect what they see as their customer goodwill and their proprietary information. The bipartisan bill that you should all be paying attention to at the moment is the Workforce Mobility Act of 2021. This is a bipartisan bill introduced in the Senate, which would prohibit the use of non-compete agreements in the context of commercial enterprise, except under very specific circumstances, including, as is common, a seller of a business interest or a dissolution of a partnership. Both circumstances where it's fairly common that one side will want a non-compete agreement to protect the interest that they have either purchased or disassociated with. And in this particular bill, in either case, in either circumstance, narrow circumstance under which non-compete agreements would be allowed, these non-compete agreements would be further limited to those specific to similar business interests in geographic areas where the business being sold conducted business prior to the agreement. This is a very, very narrow allowance for non-compete agreements under this federal legislation. Will this legislation pass? It's been attempted before. It's highly likely that this act would be subject to extremely strong lobbying efforts and would face a great deal of resistance. Nonetheless, certainly something to keep on your radar. Perhaps more imminently is increased state lawmaking related to non-compete agreements. You've likely read about the DC so-called non-compete ban, which was signed into law just last month. We've written a great deal about it on the Vinson and Elkins Labor and Employment blog, Managing the Modern Workforce. The DC non-compete ban basically bans all non-compete agreements. And interestingly, it also purports to ban non-compete agreements that would prohibit employees from competitive employment while they're still in your employ. It also creates a private cause of action for violations. Now, we fully expect that there will be further clarity regarding the actual meaning of this state law, but nonetheless, I think it's indicative of the kind of hostile state legislative lawmaking that we're seeing that could greatly impact the way that your company drafts non-competition agreements. Earlier this week, in fact, in New York, a legislative committee advanced 2 additional bills. One, again, banning no-poach agreements, and the other actually voiding settlement agreements that would include clauses barring employees from reapplying for jobs. So this is a really hot area of state lawmaking right now. And we would encourage you to be conscious of those laws and do keep on top of new news and new laws that are being signed into effect. Further to that point, in January 2020, which may be the furthest thing from our minds, given the fact that the COVID-19 pandemic was fully underway within a month, the FTC held a workshop on non-compete agreements, including, among other things, a workshop on its potential ability to regulate restrictive covenants, which would, and again, be a significant change from before. And in March 2020, going to that state hostility, 19 state attorneys generals submitted a paper laying out their objections to non-competition agreements, both as a matter of policy and as a matter of law, but largely focusing on what those attorneys generals saw as a detrimental effect on the workforces in their states. Indeed, we have seen a rise in legal actions by state attorney general's offices, whose jurisdiction generally arises out of their ability to police antitrust activity or police unconscionable or unenforceable contracts under state law. So the case everybody hopefully knows about is the Jimmy John case, which was during the Obama administration, pursuant to which the Jimmy John's gourmet sandwich shop agreed to stop signing up sandwich makers to non-competition agreements. That was through a settlement with the New York Attorney General's office. These kinds of cases have not stopped. They have not slowed down. Now, yes, it's true that many of these relate to hourly workers, which should certainly be an area where your ears prick up when you're dealing with non-competition agreements for those who may not, as part of their daily activities, come into contact with proprietary information, for example. But in an era where workers are being laid off due to COVID-19, I think it's safe to assume that the state attorney general in your state is on the lookout for agreements that it sees as unfair, unconscionable, or having a restraint on trade that that state, as a matter of public policy, simply will not accept. So in light of all this, a lot of employers for whom non-competes are an important protection are really asking what they need to be doing right now. I think, starting off here, the first bullet point, a lot of recent laws base their prohibition on non-competition agreements on the salary that the individual to be restrained may or may not be earning. Some laws will use as their basis the federal poverty line. Some will use a minimum wage. For example, they'll say 250% of the federal poverty line for those employees who are below that threshold. No non-competition agreement will be allowed, something like that. We've also seen variations recently on a lot of state laws banning non-competes for non-exempt workers. For example, you might look at states like Massachusetts or New York, where different laws are focused on the categories of workers for which non-competition agreements are allowed. But then on the other hand, something else to be highly conscious of is, for example, the state of Washington. $100,000 for employees and $250,000 for contractors. When you're dealing with employees who may make less than that, and if that seems like a nebulous way of categorizing it, yes, that is a law that needs to be looked into in more detail to figure out exactly what constitutes the salary for those workers, what their categorization is under those states' laws, and whether or not they would fall under the prohibition of, for example, Washington state law as a non-competition in violation of that state's statutes. Really tying into Lindsay's emphasis on the need for narrowly tailored and reasonable restraints, I think it's incredibly important at this day and age not to gloss over the details in provisions such as non-solicitation agreements or non-disclosure agreements. The employee non-solicit, for example, contract, you may not solicit employees of our company after you, employee, are no longer employed by us, right? That's the classic employee non-solicit. But that is not a very tailored approach. For example, if you're talking about a global company, prohibiting a departing employee from soliciting everybody that works for that company may not be reasonably tailored in the eyes of the law. Let's look at the actual nature of the company and the nature of the position in which the executive or employee is sitting. I don't like to gloss over the details in what can sometimes, frankly, be an afterthought for some employers when these agreements are being drafted, because at the end of the day, you may very well be able to have an enforceable employee non-solicit, but it needs to be reasonably tailored. Courts are taking the same approach with regard to customer non-solicitation agreements as they typically take with non-competition agreements. Your customer non-solicitation agreement with a departing employee needs to take into consideration the scope of that employee's work and the scope of the company overall. A reasonably tailored employee non-solicit is one that has avoided sweeping into its scope a kitchen sink generic prohibition. You have to assume, unless otherwise provided for under your state's law, that customer non-solicits and employee non-solicits will be treated just as aggressively as a classic non-competition agreement. This is the third point here, many of these new laws, which are quite hostile towards non-competition agreements, include an allowance for otherwise lawful agreements to protect confidential information. What this means for you is that your non-disclosure agreements have become the star and king of your overall trade secret protection program. If your non-competes are under battle with state laws and potential federal laws, you must have a strong non-disclosure agreement to take care of the customer information, the proprietary information that your company overall has. The number one thing that I focus on when I'm looking at a confidentiality agreement or a non-disclosure agreement is how inclusive or explicit does the definition of confidential information need to be? And I think, again, this is one area where sometimes we can be tempted to just sort of move beyond it and just say, oh, well, it's anything that's confidential. And maybe that's okay for the agreement at hand, but I think it's really crucial to, number one, consider the nature of the relationship between the company and the person that will be signing the NDA. What is the length of that relationship? Is this a temporary employee? Is this a permanent employee? What kind of policies will they be signed up to after they sign on to your NDA? What kind of information will they have access to? How are they going to know whether or not they're in compliance? If your NDA references merely information of the company, can that employee discern what constitutes confidential information under that agreement? It goes to the ambiguity or not of your agreement and therefore to its potential enforceability. The other factor to consider here is whether NDAs have been distributed broadly enough among your employees, or whether they have heretofore been limited solely to certain employees. Do you need, in light of the coming battle in which you will have to defend your customer goodwill, the information that your company has, do they need to be distributed to other employees? And I think now is really the time to consider whether or not it's necessary to further distribute these agreements, to amend these agreements, to look at that definition of confidential information. And then last but not least, in light of the scrutiny of non-competition agreements, I'm predicting that we may well see a rise of the use of what I'm going to call alternative contractual provisions. Many states have developed a pretty complex body of case law surrounding these kinds of provisions, but I just want to put them on your radar because I do think that they are going to become an important key member of certain states, certain companies' arsenals, depending on what states they're in. The first one, this is the alternative contractual provision, is just basically compensation. So in other words, offering somebody a choice to compete, to be able to compete, or not to be able to compete. And if they choose the latter, they get compensation to which they would not otherwise have been entitled. And this wouldn't be a forfeiture situation because I think that may well be termed a non-competition agreement itself. But when you're talking about a situation where an employee is offered the choice to either compete, or to preserve the ability to compete or not to compete in exchange for money, that may well be a way that companies can not only ensure more likely that the employee will comply with the agreement, but that it may withstand certain kinds of scrutiny under state laws. Another option here is what you guys may know as garden leave. Basically, what that means is it would be a contractually enforceable notice period during which the employee remains on the payroll. Yes, they're on the payroll, but if the confidential information, if the customer relationships are important enough, and if the state law is an issue, you may well want to consider the viability of these alternative contractual provisions. And now, Lindsay and I would be very pleased to review your questions. Please enter those into the chat function.
We look forward to discussing these issues with you offline. You have our contact information, and you'll have a copy of our slide deck. We will look for your questions, but thank you for joining us.
So on the last bit, when you were talking about compensated non-competition, so I'm immediately thinking of a severance agreement. So is there a lenience towards non-competition language and enforcement in a severance agreement because you are basically being deemed to receive compensation for choosing not to compete?
The answer to that is no. There is no lenience towards a non-competition agreement entered into as part of a severance. The classic severance agreement, of course, is that you forfeit items such as severance in the event that you default on the other provisions of the agreement. The compensated non-compete is really sort of an alternative provision that would look very different from the classic severance agreement in that it would not involve a forfeiture.